Hi guys, I hope everyone is having a good week. Today we're in week 3 looking at chapters 4 and 5, starting obviously with chapter 4, which focuses on legal traditions. Now, what do I mean when I say legal tradition? Well, typically we are referring to deeply rooted attitudes about things like the nature of the law, the role of the law, how a legal system should be organized and operated, and the way the law is or should be made and applied. Legal traditions should not be confused with legal systems themselves, which refer to a country's legal institutions, procedures, and rules. Because we only have 8 weeks in the course, it would be impossible to discuss the legal systems of every country or every point of the legal systems of countries that I found to be interesting. So instead, we try to group countries together based on a variety of factors. In those groups, however, we can't lose sight of the fact that no matter how many similarities there are in legal traditions between countries, each of those countries has different legal systems in place. Now, the text classifies countries using 4 legal traditions: common, civil, religious or philosophical, and hybrid. And generally, each of those legal traditions is influenced by specific sub traditions. So let's talk about the common legal tradition first. Here, the text identifies the 3 major sub traditions that form the common legal tradition as custom, feudal practices, and equity. And Blackstone notes that the features of legal custom are that it is ancient, continuous, peaceable, legally reasonable, certain, compulsory, and consistent. And in the common legal tradition, the concept of precedent is important because it provides a way to identify custom through reference to earlier case decisions. So basically, this is how things are, so this is how things were, so this is how things are. Now, with civil legal tradition, and actually, before we get too far into the civil legal tradition, it's important to point out that um, civil law, as we're talking about here, is not the same thing as we commonly think of when we're talking about civil law in the United States. So, civil law in the United States typically refers to a specific type of law dealing with private wrongs. So, for example, personal injury lawsuits. Whereas in most parts of the world, civil law is referring to a tradition based on written codes. And here we're using the civil law definition from other parts of the world. Now, the text identifies the 3 major sub-traditions of civil legal tradition as Roman law, canon law, and codification. One big difference between common law codes and civil law codes is that common law codes do not abolish all prior law for that topic. And that's because the codes under common law are not revolutionary. Instead, the claim is to perfect and supplement prior law. Now, the next legal tradition the text looks at is the religious or philosophical legal tradition. And the primary focus for our purposes here is on the Islamic legal tradition. And Islam recognizes no distinction between a legal system and other controls on a person's behavior. Islamic law, unlike other traditions, is intrinsic to Islamic faith and life in Islamic countries. So it makes sense that the primary components of Islamic law are going to be the Holy Book of Islam, which is the Quran, and the Sunnah, which is statements and deeds of the Prophet. Now, the Sunnah is reported in hadiths, which contain the statement itself, an indication of its authority, and a comment regarding the report as being something that Muhammad said, did, or approved. Now, because these 2 books were not even close to making up a comprehensive criminal code on their own, consensus by jurists and analogical reasoning were added. Now, within the Islamic legal tradition, there are 5 schools of law, which are discussed in detail on page 97 of the text. One of those schools of law is based upon teacher jurist Shafia his outlook basically, which is a slightly more modern view that proposes a compromise between those believing that all rules must be derived from the Quran or Sunnah and those believing that the law should be elaborated through the use of human reason and personal opinion. Now, the fourth legal tradition that we're looking at is the hybrid legal tradition. And the text focus is on the legal tradition of Eastern Asia, which is influenced by both civil and common legal traditions. The three major sub-traditions which make up the Eastern Asia tradition are Confucianism, collectivism and context, and legal informalism. Now, Confucianism is moral and ethical system that is the single most important source of Eastern Asia legal tradition. Then we have collectivism and context, where the emphasis is on the group over the individual, and it encourages looking at the context surrounding the act and the crime more than the actual crime itself. And then lastly, legal informalism, which is the more informal system of justice that focuses more on reconciliation, restitution, and reintegration versus, say, incapacitation or some of the other types of punishment that we're going to discuss later in the course. Now, the text also looks at private versus public law to determine where legal rights and obligations are falling. Under common law tradition, legal rights and obligations are with the public because the public is said to have a legal personality. An example of that would be the state representing society, essentially. And then we have with civil legal traditions, it depends. Some matters are the sole concern of individuals, and that would be private law. But others concern government activities or people acting in the public interest, and that's public law. Now, under Islamic legal tradition, the emphasis is on the individual, so private law generally prevails, with exception. Under the Eastern Asia legal tradition, both private and public law function together as the state tries to enforce proper behavior, but again, there's a preference for the informal or private action. Now, it's also important to understand the role of the judiciary in relation to other government branches. Under the common legal tradition, the judicial, legislative, and executive branches all provide checks and balances to each other. Under civil legal tradition, the judiciary is isolated but has equal power. Under Islamic legal tradition, courts are subordinate to the Sharia and work as a stabilizing entity that allows individuals to carry on their own affairs. And then under the Eastern Asia legal tradition, the judiciary is viewed differently depending on whether the country operates under socialism, where courts would be subordinate to the legislature, or democracy, where courts have independence from and share power with the other branches. Now, one of our focuses up to this point has been substantive law, which very broadly concerns where laws come from and how they're defined. So let's discuss briefly the primary sources of law for each of the traditions that we're looking at. For common tradition, the primary source is custom, so how things have been done in the past. For civil tradition, the primary source of law is the written code that's provided by the legislatures or in other places the rulers. In the Islamic legal tradition, the primary source of law is divine revelation. And in the Eastern Asia tradition, the primary source of law comes from the principles of Confucianism. Now, despite the sources of law, each system must provide ways to update, modify, and supplement the source of law in their respective legal traditions. So basically, everybody needs a little flexibility to adapt with the times. And that goes back to our procedural law discussion. Now, under common law, flexibility is provided by letting judges adapt as they seek solutions to particular situations, and this is referred to as particularization. Under civil tradition, the flexibility comes in when judges are allowed to come to different results as long as the judge's reasoning is logical and based on the written code. Judges also have discretion to consider some issues to be factual rather than legal questions, which can affect their decisions as well. Now, under the Islamic legal tradition, flexibility is provided in very limited situations where cases are resolved outside of the typically rigid requirements discussed in the text. Now, the Eastern Asia tradition has more flexibility, and we see that through a preference for informal procedures and sanctions, and specifically in China by having more non-specific laws. Now that covers chapter 4. So let's move into chapter 5, which is talking about substantive and procedural law within the 4 legal traditions. So at the start of chapter 5, the author is nice enough to give us another rundown of substantive law, basically drilling it in our heads that substantive law defines criminal behavior and has 4 general characteristics: politicality, specificity, uniformity, and penal sanction. Without these, the act is not criminal. Now, we also get another rundown of the major principles to determine whether or not behaviors qualify as criminal. And there we need mens rea, actus reus, concurrence, harm, causation, punishment, and legality. And the text is giving us several examples on page 115 through 118, including a discussion of criminal intent and the different standards. So, for example, Muslim scholars distinguish between general and specific criminal intent, and specific criminal intent may have to be proved to show that the act under question was committed without justification. Okay, now let's look at substantive law across the legal traditions we've been discussing. So, substantive law in the common legal tradition. The historical example given here is England, but the text looks at Scotland as a more contemporary example, because to a greater extent than most other common law countries, Scottish courts are taking an active role in judge-made substantive law in addition to legislation-based law. Now, substantive law in the civil legal tradition is where civil law judges are basically expected to apply the code's provision to specific cases. So here, you'd kind of assume that the civil code books are this incredibly extensive, comprehensive guide that dreams up every imaginable scenario, but really not so much. In fact, common law statute books tend to be more extensive and try to anticipate more likely scenarios. And the text makes this point on pages 121 through 122 by looking at the crime of theft as defined in the Colorado revised statutes versus the German and the French theft codes, which supply general principles from which logical deduction provides a resolution in each case. This illustrates the civil law preference for general principles. Now, substantive law in the Islamic legal tradition has 3 categories of crime identified by the Sharia. Hudud crimes, which are the most serious and are considered to be offenses against God. And there's a disagreement as to the exact number, but I think there are 6 that are discussed in the text. One is adultery, and essentially that's because if left unchecked, it could disrupt the social fabric of the community. And then it goes into others, I believe, use of intoxicants, highway robbery, things of that nature. Now, the text notes that while the harshness of the penalties for these offenses is often emphasized, they are at least somewhat balanced by the rigorous rules of evidence that apply to those crimes. Then we have qisas crimes, which are also serious, but where the harm is to the individual rather than God. And that's going to be your murders, your assaults, things like that. And the penalty for these types of offenses is typically retaliation, so that biblical eye for an eye mentality, or financial compensation, which is referred to as use of diya. Then we have the tazar crimes, which are basically the catch-all. It's the catch-all provision for all other offenses that aren't covered in the other 2 that we just talked about. And new crimes can be added there, but these crimes are going to range from offenses to offenses that would be considered violations of proper Muslim conduct, so eating pork, dressing provocatively, things like that, and ones that are necessary for an orderly society, so traffic laws, etc. Now, substantive law in the Eastern Asia legal tradition operates from the premise that the legal informalism that is preferred under the tradition works best when substantive law is flexible and also fairly vague. So really, I mean, if we're thinking about it and comparing everything, the issues of substantive law don't vary too much among the four legal traditions. The real differences are going to be in the criminal procedures. And there are too many aspects of procedural law to discuss here, so our text picks two to focus on: the adjudicatory process and judicial review. Now, the adjudicatory process is typically either adversarial or accusatorial or inquisitorial. And the adversarial process is used in common legal tradition, whereas the inquisitorial is used in the civil legal tradition. The Islamic and Eastern Asia legal traditions offer a unique combination of both. Now, this is laid out in the table on 129, page 129, but generally, the adversarial process is one where you have a trial before an impartial official, typically a judge, who acts as a kind of a referee between the adversarial parties. So in the United States, it would be a trial in front of a judge where the judge is refereeing between the state and the defendant. Under the inquisitorial process, a trial is more of a continuing investigation where the judge is actively seeking to figure out what it is that happened. Now, we also have judicial review, which very simply allows citizens to be able to challenge laws or actions that may violate the values of a society. And the text offers 3 stages for achieving this rule of law. 1, certain values are recognized as supreme. Then 2nd, values are reduced to written form. And then 3rd, procedures are provided for holding the government to a nation's fundamental values. Now, excuse me. There's 3 separate models for judicial review that are provided: the diffuse model, the mixed model, and the concentrated model. Now, under the diffuse model, the country's entire judiciary, so all the courts in the country, have the duty of constitutional control, and an example of that would be the United States. Then we have our mixed model, where there is a specific government entity that reviews the constitutionality of laws, but all courts in the country have the power to ignore the laws that they view as unconstitutional. So an example here is actually 2 examples, both Venezuela and Portugal, who are described as having 2 of the most extensive systems of judicial review in the world. And they're described that way because in those countries, all of the courts in the countries can determine the constitutionality of laws, but each country also has a specific court who's charged with that responsibility. And then we have the concentrated model, which is where there is a specific government entity that rules on the constitutionality of laws, so there's less inconsistency. And examples there are Austria and Italy. Now, the text addresses judicial review in the Islamic legal tradition and in China separately on pages 144 and 145, because many countries under Islamic legal tradition and in China don't operate under a rule of law and thus have incomplete or basically non-existent procedures for judicial review. So that is it for chapters 4 and 5. Thanks for hanging in there. I know it was kind of dry. I hope you guys have a great week, and I will see you next week.